Welcome back, everyone, to AJ 101 Online. So this is Criminal Law Online, and this is our first lecture of the semester, and we're going to be going over Chapter 1. And the title of this chapter is The Scope and Source of Criminal Law. So kind of, what's it all about, and where did it come from, and was it there a long time ago, or did we just invent this stuff now, or what? If you look at the bottom left here, you can also see the name of the textbook, California Criminal Law Concepts. So please make sure you have your textbook with you. Not necessarily while you're listening to the lecture, although that would be great, but you want to be able to take uh, the textbook examples. They have some scenarios and examples in there that will help you fit together some of the pieces that we're going to be talking about, so you'll be able to understand the context of some of the laws and things that we're going to go over. Without that textbook, you're merely going to be memorizing, and that's not really going to help you, especially in this class, because there are a lot of terms and definitions and things like that, and you need to be able to apply them, not just memorize them. So please pick up the 2016 edition of California Criminal Law Concepts so you can make your class a lot more enjoyable, and you will certainly gain a lot more knowledge as we start to go through. Also, really quick, I wanted to mention that in this course, I do add in the course content area in each week, basically a terminology or definition kind of worksheet. It might be titled as a quiz on there. Don't worry about it, because as you read, because I'm sure you've already gone through Blackboard and read everything and you're up to speed, because that's the kind of students that you are, that you know that is not graded. It is simply a tool for you to use as a study guide to understand the definitions and the terms. So on that one sheet piece of paper, on the left-hand side will be the term, on the right-hand side will be the definition, and your job is to kind of match them up, and that will help you kind of understand. You'll be able to pick those terms and corresponding definitions out a little bit better, which will, I'm sure, help you know a little bit more when it comes quiz time or test time. So there you have that. So let's jump into now Chapter 1, and we're going to be talking again about the scope and source of criminal law. So kind of where did it come from? Well, the basic purpose of criminal law is to establish limits on certain human behavior or activity considered to be harmful to society. If you look down below here, you can see the definition of a crime. Crime is social conduct considered harmful to individuals and to our institutions, and therefore made punishable by law. So digging into it a little bit deeper, though, let's kind of discuss it for a second. Let's take just a few minutes and again understand the basic purpose of criminal law is to establish limits on certain human behavior or activity considered to be harmful to society. And yes, we'll have some differences of opinion on that, on what we believe is harmful to society. An example very, very quickly is the issue over marijuana, harmful to society or not. Some of you say no, some of you say yes. So again, we will have differences of opinion on some of these things. But one thing you need to know is that criminal law is not about oppressing people or preventing them from enjoying life. Laws are tools. We use these tools to build and maintain an orderly society. Imagine if we had no laws at all, what society would actually be like. If each of us lived in a state of isolation, away from all other human beings, of course, there would be little, if any, need for criminal law or any laws at all, for that matter. Obviously, though, we don't. We don't exist as hermits. In fact, we live in a very complex society requiring social interaction and daily interaction with many, many other people that are different from us. And in such a society, each person must know what he or she can and cannot legally do regarding our frequent contacts and dealings with others. In order to avoid chaos, basically, we must have rules then to govern our activity. This is why, for example, we have rules of the road. So we have rules regarding the operation of motor vehicles on our streets and highways. Imagine what it would be like if there were no rules at all on the road. You could just drive any way you wanted to drive, any direction, any speed, any whatever. Imagine the chaos that would happen. So that's kind of why we have those types of rules. And even in a complex society such as ours, if everyone did the right thing in relation to all other people, we would still need a few criminal laws because, unfortunately, there will always be those individuals who attempt to oppress the helpless, who steal from others, or in one way violate the life, liberty, or property of other people by force, fear, fraud, and things like that. So, unfortunately, we're going to need some laws for those that do that. Now, historically, our first criminal laws came into being as a result of society's struggle to control those persons whose antisocial activity was destructive of a desirable environment in which people wanted to live, meaning there were people that wanted safety, stability, and things like that. And then there were those that disrupted that. Okay, so I mean, you can kind of see why you need laws. Safety, stability, and integrity are necessary for the healthy growth and benefit of a community as a whole. So even, you can look way back in the olden days, if you will. You still wanted safety in your communities. You wanted stability, just as you do now. So, kind of look at it that way. Now, we may think of crime as a violation of the basic controls of society, and we may think of criminal law as necessary to deter misconduct and otherwise deal with those individuals who would disrupt society. Criminal law is an instrument of social control. Okay, without laws, criminal or civil, we would have no protection from the predatory whims of others, meaning those that wanted to do us harm or take advantage of us or things like that. And in order to gain the protection of society's laws, those law-abiding members must be willing to give up a small part of their freedom as well to do just as they want at all times. So you can't just do what you want at all times. You have to give a little bit of that up because there are some laws that tell us, hey, these are things we can't do and things that we can do. So, and this is especially true when one individual's activities interfere with the rights of others. So, and we'll talk more about that. So where did it come from? As we kind of move into this a little bit more, most of our early criminal laws were based on custom or other recognized patterns of human behavior which appeared to be beneficial to the group as a whole. Even today, laws pertaining to some things can be traced kind of way back, and we'll take a look at that in a few minutes. Criminal law, if you don't know, and if you do, great, and if you don't, now you're going to know, is old. It's almost as ancient in one form or another as humankind on Earth. No doubt even early cavemen eventually established some sort of basic rules as to, maybe who would eat first, who might, tend the fire, who might stand guard. So I mean, we know that there were rules back then, and they're meant again to kind of benefit the entire group. So we kind of we see that and we know that. As family groups eventually joined one another to form tribes, and new rules or laws were developed to avoid conflict and to assure the peaceful functioning of the group. Things kind of changed a little bit. Children were no doubt taught local customs and what they call taboos by parents and other members of the tribe. As society developed and began to place its thoughts in writing, there emerged the concept of kind of what we call statutory law, okay, or written law. So when you hear that word statutory, you can kind of think of written. This was to have a very profound effect on the entire civilized world, because then you had written laws, things that were written down. It wasn't just word of mouth, it was the development of rules and written laws, which we actually have today. Now, so the first written law was in the form of, symbols chiseled into rocks, rock tablets, or impressed on wet clay tables, which were then kind of baked, and they had these in there. And then after that, we're going to see what we call here the Code of Hammurabi. And this was the first major code of written law. And it was developed almost 3,800 years ago. And we can trace many of our legal concepts and procedures back to this code. And real quick, I'm going to post a video that's actually pretty cool. It's about 4 or 5 minutes long, and it kind of goes over the Code of Hammurabi in a little more detail. So you can look forward to seeing that. But I just wanted to kind of let you know that. And so back to where we're at. So we can trace many of these legal concepts, procedures, and things back to this Code of Hammurabi, such as judges, juries, written contracts, swearing in of witnesses, and lying or perjury, if you will, as a crime. And it's kind of interesting how long ago this actually took place. But again, so one of the most famous examples of early written law is the Code of Hammurabi. It was a large stone tablet now preserved in the Louvre Museum in Paris, was believed by scholars to have been written all the way back in 1790 BC by King Hammurabi of Babylonia during his reign, and that was from about 1792 to 1750 BC. And again, we can trace a lot of these things that we use now all the way back to that. So I think that's actually kind of cool when you think about it. So some other influences and developments that kind of came along. Well, we had the Norman or the French period. In 1066, William I of England conquered the British Isles at the Battle of Hastings. The English courts became kind of more centralized then, and they were known as the Royal Court. And then we started to see the Westminster period, which is from 1285 to 1500, and customs that were there started to lead to what we call now stare decisis, or precedent. And that actually is kind of cool because it stayed with us. We have what we call case law now, which is precedent law, that started all the way from this phrase that I just mentioned here, stare decisis. So again, things that we think, hey, why does it really matter? Well, it does matter because case law precedent started from this phrase all the way back in 1285 through 1500 in this Westminster period. So again, kind of we're learning some things that we really need to know here. And then we saw the development, if you will, of kind of common law. And as defined by Blackstone, common law consists of doctrines that are not set down in any written statute or ordinance, but rather depend upon a long time usage for their authority. So basically meaning, hey, this is stuff that's just been going on, kind of like customs over time, therefore we developed it. So kind of if we go back over now, we look at laws developed by judges through decisions of courts rather than through legislative statutes. So unwritten law based on custom gains strength over time. So they did this way back when, and then they continued to do it then, and maybe there's some forms of it now. So that's kind of what we call common law. And we'll talk a little bit more about common law in a few minutes. So the adoption of common law in America, the first settlers from England formed agreements among themselves called compacts, which contained much of the common law of England and was adopted basically for their governance. So as the first settlers from England arrived, they formed these agreements among themselves, again called compacts, and In these compacts, they adopted much of the common law of England for their governance. Following the Declaration of Independence, many states either adopted the common law outright or passed criminal statutes, which in fact incorporated into written law most of the basic principles of common law. So you can see the importance of what we're talking about here. And when you look in, talking about crime in California, and we're going to get to that in a minute. We also need to know that common law crimes, there are no common law unwritten crimes in this state, in California. Okay. On the contrary, for an act or omission to constitute a crime in California, and we'll get into that in a little bit, it must be a violation of a written statute, and it has to provide a penalty. So does common law exist in California? Well, throughout the United States, some principles of common law are still kind of around, if you will, but for California, we don't recognize common law or unwritten law. Okay, so hopefully that kind of clears it up. So now we're here for an act or omission to constitute a crime in California. It has to be in violation of a written statute. So it has to be written down. And that statute must provide a penalty for its violation. So hopefully that kind of makes sense to you a little bit. So those are things that, we're a little bit more specific in California right now. So where can you find, laws, and where do they come from? What are their sources, if you will? Well, you have the United States and state constitutions. Now, make sure you look at some of those videos I posted. I believe either in the information area or the content. I think it was in the information area. There's 5 videos on the court systems, all the way from state court to federal court to appellate court, etc. You should watch those. They're about 4 or 5 minutes a piece, and they're very, very informative, and it will really help you understand the court system, which you're going to need to know as we start to move through the textbook anyway. But back to the sources of criminal law, United States and state constitutions. So each state does have a constitution, if you don't know. So you have the United States Constitution and state constitutions. Then you're looking at statutes, which are laws passed by Congress, state legislatures, and local governments. So that's another source. And then you have prevailing decisions, case laws. Remember we talked about that? The stare decisis, the case laws of the appellate courts in criminal cases. So these are some sources that you'll be able to glean, where did criminal law come from? And again, not to go too far off track, I also would suggest that you look at the PowerPoint that I posted on the Bill of Rights, because we are going to have a lot of discussions about how laws impact, the Bill of Rights, which is the first 10 amendments to the Constitution, and then I throw in the 14th because it really, really is so important. So these are sources. Okay, some sources. Federal state constitution. So the U.S. Constitution is the supreme law of the land. So that's the United States Constitution. We recognize both federal and state constitutions as the law of the land, and these constitutions define and limit the powers of the government, and they provide for the establishment and maintenance of our court system. So, there are going to be decisions of courts, and that are going to be kind of tried against the Constitution, if you will. So just kind of understand that these constitutions, okay, these federal and state constitution, we view them again as the law of the land, and they help define and limit the powers of government, because the government can't just run amok. So there are limitations on the government as well. And again, they also provide for the establishment and maintenance of our court system. So the Bill of Rights, and we've talked a little, I just touched on it a few minutes ago, but it really is important. It consists of the first 10 amendments to to the United States Constitution, adopted in 1787, ratified in 1789. It's all important, so don't think that just because I hit on a couple of these that the other ones aren't important, but those that have the greatest impact to criminal law will be the Fourth Amendment, that's going to talk about searches and seizure for the most part. You can read more in detail on that later. The Fifth Amendment, which really focuses on the rights of persons or self-incrimination, and things like that. So you'll see a lot of that Fourth and Fifth Amendment. You'll also see a little bit of the Sixth Amendment in there as well, and the Eighth Amendment. But the Fourth and Fifth Amendment are very, very important when it comes to California criminal law. So now let's kind of switch gears a little bit, and let's look at the California Constitution and kind of like what it stands for. So the California Constitution establishes the duties, powers, structure, and function of the government of the state of California. The California Constitution is one of the longest in the world. It begins with a Declaration of Rights similar to the U.S. Constitution's Bill of Rights, and it talks about right against unreasonable search and seizure, the right against self-incrimination, and so forth. So understand that there is the United States Constitution. I guess at the end of the day, this is what I'm trying to get at, and then there is the California Constitution. Okay, and again, the California Constitution does have some of the things that are listed in the other one. So the purpose and nature of criminal law. Well, the purpose of criminal law is to define socially intolerable conduct and to hold conduct within limits which are reasonably acceptable from the social point of view. And again, some of us will have some differences of opinion on what we believe is acceptable, or from a social aspect, if you will, and what is really not acceptable. So that's kind of an interesting dynamic. So crimes are prohibited and punished on the grounds of public policy to prevent injury to the public. Injury to the public may include things like destruction or interference with government, human life, private property, or other valued institutions or interest. Such considerations as desire for vengeance or compensation for injury may also kind of be involved, and punishment is often said to be the purpose of criminal law. Now it's really only true up to a point. The real purpose of criminal law, again, as we just read, is to define social and intolerable conduct and to hold those people accountable within those limits from a social point of view. So, perhaps it may be said that whatever purpose is served by punishment, one purpose is that compelling persons to cease or refrain from committing crime and forcing or persuading them to conform to a set of rules or conduct designed for the protection of government life and property. So kind of another way of looking at it, if you will. So that's kind of like just getting us in. We talked a little bit about, kind of the background, if you will. Now I'm going to go through the rest of this a little bit quicker than probably the beginning, but we'll hit on the high points here. So now let's kind of look at what a definition of a crime is. So we've gone through that introduction thing, and now we're in California here, as you can see, and we're going to look at, okay, well, we talked about all that stuff leading up to it. So what is actually a crime? Well, a crime is a public offense committed or omitted in violation of law, commanding or forbidding it, when annexed upon conviction, meaning like if you are convicted, results in punishment of certain things. Now, those things are death, imprisonment, fine, removal from office, if you're a political figure or similar, or disqualification from office, meaning that you can't hold a certain office. Okay, so that's, the word crime in its more extended sense includes every violation of any public law. A general course of conduct, practice, habit, mode of life, or status which is prejudicial to the public welfare may be prohibited by law, and punished therefore may be provided by the state. So basically every course of conduct or practice or habit or mode of life or status falling within that class of wrongs is covered by the term crime. So there you have it. All public offenses or crimes in California are statutory. Okay, so keep that in mind. Again, and statutory means what? It means written. Okay, so remember, we don't follow that the common law theme. Okay, so it really has to be written down in order for that. But now you kind of know what the definition of a crime is in general. Moreover, you know what, if you commit that public offense, it can result in all of those things that were listed below: death, imprisonment, fine, removal from office, or disqualification to hold a certain office. Now, we talked earlier a little bit about that phrase called stare decisis. Okay, and that was even early on, and it kind of tells you how you can pronounce it. It's pronounced a few different ways, but what it really means is adhering to the precedent, meaning that came before it. So previously decided cases, they do have a great impact and influence on the decision of current cases, and that's kind of the phrase, that's where case law comes in. Okay, and this provides for a consistency in the law. And when it comes to departure from the precedent, or those things that we've done before, if you will, the courts don't have to adhere to precedent. There are times when the courts kind of, sets law into a new or modified direction, and that may be due to new facts or, that are in that current case, but the law does rely on past practice or case law or precedent, if you will, to continue to provide consistency in certain decisions that are made within the law. So, that's just something that you kind of need to understand. So we know what a crime is now. We talked about stare decisis and precedent in cases. So let's take a minute and we'll look at classification of law. And what does that really even mean? Well, criminal law may be classified into two broad categories. It is either substantive laws defining crimes, if you will, or adjective, which are the rules of procedure for administering the law. So substantive law, laws defining crimes. It is the activity that is prohibited or required: theft, assault, etc. Laws that courts must enforce. Now, adjective or procedural, if you will, law, those are the rules for administering the law. An example, rules for police when submitting evidence to a court. So there are rules, procedural rules, adjective procedural rules on packaging evidence and submitting it to court. Okay, versus, okay, we're going to go back up because we're trying to clarify these. Substantive law, which is the law defining crimes: theft and its definition, assault and its definition. Does that kind of make sense? And I hope it does. So those are kind of the difference between substantive and adjective laws. Now, peace officers, which I hope that's what you want to be, need to have some understanding of adjective law or procedural law, because it includes such things as, again, as what I said, rules of submitting evidence in court and arraignment of those charged with a crime. Procedural law is also concerned with carrying out court orders, you know, compensation for injuries, classification of crimes and punishment, and things like that. So this is important for you to learn as a law enforcement officer, not just the definition or knowing, hey, theft is this code section, but those maybe some rules or procedures that are attached to it. And that's why it's really, really important for you to kind of understand that. So we've gotten through the substantive and the adjective. Now let's look at criminal law versus civil law. And I'm sure you've heard of civil law, and you've heard the phrase criminal law. And if you've done the definition sheet, the term sheet, you probably know a little bit about both. But criminal law, an offense against society or the public. Okay, and the penalty again can include death, prison, fine, etc. Civil law, legal rules regarding contracts and agreements. Violations of civil law, they're not crimes in essence, they're called torts. Okay, and the remedy for that, for a violation of a tort or a civil wrong or civil law, typically is handled by some type of compensation, okay, or punitive compensation, basically money or a fine. That's typically how civil law goes. The differences include the degree of proof required, jury votes required for a verdict, and rules of evidence. So there are differences in trials. A criminal trial will have certain guidelines and rules that might be that are actually slightly different from, say, a civil trial. Okay, so you just kind of have to understand the two, and we're not going to get into the meat of really what the difference is there, but you do need to know that there are some differences there, and again, some of those can be the rules of evidence. In a criminal trial, they may not let certain evidence in, and in a civil trial, they might. So again, there are some of those differences there. So as we start to kind of move a little bit more, we've talked about some classifications of laws and some concepts and things like that, and so that kind of brings us to the question of statute of limitation, meaning like, well, you know, are there times involved in crimes, and do they last forever? Or if somebody commits a crime and gets away with it, if you find out about it 10 years later, can you still prosecute them for it? So this falls under what we're going to talk about right now. So the statute of limitation places a limit on the amount of time which may legally pass between the time the crime was committed or discovered, because some are different, and prosecution is started. Okay, so, you know, for a more thorough definition, Penal Code Chapter 2 talks about time of commencing criminal actions, and it covers the statute of limitation in a little bit more detail. But by a little bit more introduction or whatever, it's necessary to consider the statute of limitation on certain offenses in order to know how long after the commission or discovery of a public offense a suspect can still be prosecuted. In some cases, the time starts running from the time the crime is discovered. In other cases or instances, the statute of limitation starts running when the crime is committed. There is a difference as to the statute of limitation between felony crimes and misdemeanors, felonies being higher, misdemeanors being lower. There's also a difference in the statute of limitation between certain felonies and between certain misdemeanors. So again, you don't need to know every single one of these, but you do need to know that there are differences in there. Okay, and we'll talk a few minutes about some of the differences. So continuing on with the statute of limitations, commencement of prosecution, grand jury indictment, information filed, warrant issued. For the general felony rule, usually 3 years from the commission of a crime. And what you see after here, like you can notice here, it says PC 801. That's Penal Code 801. So if you want more meat to what we're talking about, you can go on the internet, you can Google California Penal Code 801, and you can read the entire thing. if that's really what you want to do. General misdemeanor rule, usually 1 year from the commission of a crime. When there is no statute of limitation, usually offenses punishable by death or life in prison, because there are some that don't have any. So what they mean by this one, when there's no statute of limitation, usually offenses punishable by death or life in prison. So if you murder somebody, that would fall under that. There's no statute of limitation. So if we know that you did it and you ran into hiding and we found you 20 years later, that's okay, because there's no statute of limitation on that. And hopefully that kind of makes sense. Difference between commission and discovery. Certain crimes are commenced after discovery, which could be years later. And specifically, those are a lot of specified felony sex offenses fall under this section here. So a real quick example without taking up too much time. Let's say that you have a victim of a child molestation, and typically we know that a lot of times kids don't report right away. They could reveal the crime happened to them 5 years later, or something could bring out that information. So that's why there are certain sex offenses to where some of these discovery versus commission. And hopefully that makes sense. So the commission would be like when the crime happened. Discovery would be when you knew about it. Okay? So that's, and that kind of hopefully kind of clears that up. So again, that difference between those two. And you can look in your textbook also. Page 8 kind of goes through a lot of the different things on the statute of limitations and things like that. And there are quite a few. So case citations and appeals as we kind of move on. A case citation published in the California Appellate Reports would be written as this, and we're not going to spend a lot of time on that. But if you wanted to look up a case citations or appeals, this is how it would actually look. So People v. Weaver, 44 Cal. 4th, 154. This refers to the people of California versus an individual by the name of Weaver, found in the 44th volume of the California Appellate Reports, 4th series, page 154. So, but for you to find cases, again, the internet's a wonderful thing. You can put in the name of a case law, hit enter, and you will get tons and tons of information on things like that. Case citations, just to kind of show you what it looks like, a case citation of the California Supreme Court published in the California Reports, abbreviated CAL, or simply the letter C, would be written as you'll see here, People v. Lucas, 12th Cal. 4th, 415. This refers to People of California versus an individual by the name of Lucas, found in the 12th volume of the California Reports 4 series, page 415. So again, we're not going to spend a lot of time on that, but those are things that you do have to kind of know. Moving on, Attorney General opinions. So the Attorney General, if you don't know who it is, you need to figure that out. Who is the Attorney General of the United States or even California? Could be a test question, you never know. So you need to know what the Attorney General is, and I'll come back on later and maybe tell you what the Attorney General actually is. The California State Attorney General is the lawyer, okay, the chief law officer, if you will, of the state. Okay, and opinions of the Attorney General are expressions by him or her of conclusions on legal questions which are presented to him or her by those persons whom he or she represents. Now, formal opinion is rendered when question presented is basically of general statewide interest. So the California Attorney General, let me kind of back up to make it a little bit more clear, is designated as chief law officer of the state. Their formal opinion is rendered when questions are presented of general statewide interest. Informal opinions are given on issues primarily of local interest. opinions do not have the same authority as a judicial opinion because it's an opinion. It's regarded as a quasi-judicial in nature and given, of course, great respect. These are opinions of the attorney generals, but they are not laws. Okay, so I just want you to kind of understand that. So just kind of keep that in mind. So two types of opinions that are rendered by the attorney general: the formal opinion and the informal opinion. And then we talked a little bit about the authority of the opinion. The opinions of the attorney general do not have the same authority as do opinions of the court, but they are given some weight, if you will. And police power in the state, and we're going to go through a couple of different concepts here real quick. So we're going to talk about police power of the state. Police power is not stated in the U.S. Constitution. There's nothing in there that you'll find that. States' rights are reserved in the Bill of Rights under the 10th Amendment. The federal government does not have a general police power as the states do. The exceptions are laws regarding federal property and the military. So areas of police power, under this power, the state can legislate in the following kind of 5 areas: public health, public safety, morals, general welfare, and economic prosperity. Those are things that that the state can kind of regulate. Now, your important one would be number 2, which would be public safety. So the states can kind of regulate the laws, if you will, or the powers that the police have state to state. Okay, and that's why you have some police powers that you could maybe do in this state versus some that you couldn't in another. So under these areas, again, of police power, we have that. The concept of preemption, it's controlled by the California Constitution, as you can see here. Talks a little bit more. A municipality may not legislate in regard to matters occupied by the state law if any one of the following applies. So let's read that again so we kind of understand what it means. A municipality, local jurisdiction, may not legislate in regard to matters occupied by the state law if any one of the following applies. First one, the subject matter is one of state concern and the general law occupies the entire field. Second one, the local legislation is in conflict with the state law. And the third one, the subject matter is of such statewide concern that it can no longer be deemed merely a municipal affair. So, police power, just kind of remember, police power is as broad as the legislative power of the state with 2 exceptions. Laws must be confined to local regulations, and local laws are subject to general laws, etc. So this is going to seem a little bit confusing, but don't worry about it. We're going to make it. We'll make it all the way through. Okay. So let's kind of move on because we don't spend too much time in just one area. Ex post facto, we'll talk a little bit. An ex post facto law is one passed after the commission of an act, and which changes the legal consequences of the act to the wrongdoer's prejudice, which wouldn't be fair, right? So, again, a law passed after the commission of an act that changes the legal consequences of the act to the wrongdoer's prejudice, it is prohibited by the U.S. Constitution, and you can look at the article numbers that are down there. So really, that's kind of just all you need to know for that. An ex post facto law is one which makes a crime more serious, inflicts a greater punishment, or changes the rules of evidence. Okay, now this doesn't mean that you can't change laws. Okay, but what it's talking about is, if we kind of go back here real quick, you're passing the law after the commission of an act, which changes the legal consequences to the person that did it. Does that make sense? So what would be a good example? Let's say that marijuana was legal. I mean, even though it is now, but let's just kind of back up for a minute. And you could smoke a certain amount or do whatever, blah, blah, blah. Well, then the law changes and now it's illegal. Now we can't go back and prosecute those that have used it before because it was what? It was legal. Okay, so you see how that kind of plays into that. So that's kind of a low-level example of what that is. All right, moving on. Crimes and torts. We know torts are what? Civil. Okay, crimes are criminal. We kind of got that. A crime is an offense against the state, all the people, and carries a punishment with it. A tort, again, is a private wrong, such as failure to comply with the terms of a legal contract or something similar. The civil action for a tort is designed to obtain what they call redress or payment or reimbursement. Remember, we talked about that money thing. Intent is another distinction between a crime and a tort. To render one criminally liable for an act, the person must have a criminal intent as provided in Penal Code 20, and we'll get into that a lot more down the line, but we just want to kind of get that out. So some terms that you'll see, some definitions. Hopefully you did the terminology sheet because, again, that'll help you. Mala in se, crimes that are wrong by their very nature. Mala prohibita, wrong because the crime is prohibited by statute or written law, right? Moral turpitude relates to that deemed shamefully immoral, suggests a lack of honesty, modesty, integrity, good morals. Crimen falsi, any class of crime that involves falsification. Infamous crimes, term associated with an act of vileness or moral depravity, such as sodomy or bestiality or something like that. Moving on a little bit, venue or jurisdiction, again, and we're getting close to the end here. Venue has to do with the physical or geographical location of the court in which a case is to be filed or tried. Jurisdiction has to do with the court's legal authority over the defendant, jurisdiction of the person, and the crime, jurisdiction of the subject matter he or she is accused of committing. So I know that was quick, but that's why you need the textbook, so you can kind of go through some of those things. I'll have this audio version of the PowerPoint posted along with the regular version that you can kind of flip through, but do them together at the same time with your textbook and you will get quite a bit more out of it. So that is it for chapter 1, and hopefully you got something good out of that. And I will post some of the things that I talked about earlier, like the Code of Hammurabi, and again, go through those court videos that I talked about.